We'll hear argument first this morning in Case 10-945, Florence versus the Board of Chosen Freeholders of the County of Burlington. Mr. Goldstein.
Mr. Chief Justice, may it please the Court, we ask this Court to hold that a jail may strip search an arrestee in cases of reasonable suspicion. That is the rule that was applied throughout almost the entire country in the 3 decades after Bell versus Wolfish without either administrative difficulty or any apparent increase in smuggling. We're here today, of course, because both the Burlington Jail and the Essex County Jail require every arrestee to stand 2 feet in front of a correctional officer and strip naked.
Do you apply the reasonable suspicion rule to all arrestees? I thought you were making a distinction between felons and less serious offenders.
We do apply it to all arrestees. The respondents in the U.S. Bureau of Prisons do draw a line at major versus minor offenders. I think they do that because they think that people who commit more serious crimes might be inclined to greater criminality. But our rule is one of reasonable suspicion. Our question presented draws a line at minor offenders because this class definition is only people who were arrested for minor offenses.
Is the reasonable suspicion test more easily met if it's a felon detained for a serious felony?
It is, in the view of the courts that have considered this question, absolutely. In our view, yes. Yes. And in fact,
well, then you are going on a case-by-case basis based on the offense.
There's a categorical rule, and that was adopted by these respondents, by the Bureau of Prisons, and 4 courts of appeals that says if you were arrested for a more serious offense, categorically there exists reasonable suspicion. Our case-by-case rule, it's true, applies with respect to minor offenders. And again, that's the class that was
well, how would this work with respect to individuals who have been arrested for serious offenses? Let's say someone has been arrested for assault. Let's say it's a case of domestic violence, assault. Would that be enough to justify a search?
I think you will have to ask. I know you want me to answer the question. Let me just be very clear. This is their rule. The respondents draw the major-minor offense line. The respondents apply a reasonable suspicion standard. Now, in my view —
I understand. You say that you don't want to draw that line. You want to apply it to everybody. And I'm asking you whether the mere fact that someone has been arrested for a violent offense would, in your judgment, be sufficient to provide reasonable suspicion.
If the jail made that judgment, we would think that a court would not overturn that judgment. We think that illustrates that, by contrast, when someone is arrested for not paying a fine, that there is no justification whatsoever, because the logic of their own policy is that this is a person who's inclined to violence.
But I take it what we're trying to do is to protect the individual dignity of the detainee. But it seems to me that you risk compromising that individual dignity if you say we have reasonable suspicion as to you, but not as to you. You're just setting us up. And you're setting the detainee up for a classification that may be questioned at the time and will be seen as an affront based on the person's race, based on what he said or she said to the officers coming in. Right. So it seems to me that your rule imperils individual dignity in a way that the blanket rule does not.
Well, a couple of points, Justice Kennedy. I think it's an incredibly important issue. They don't have a blanket rule. Remember, the respondents apply a reasonable suspicion standard. They do strip everyone naked, but if they're going to look for contraband, that is, look at the person's mouth, look at their anus, they apply a reasonable suspicion standard. Now, to your very serious concern that maybe we're inviting discrimination, or at least an appearance of discrimination, remember that their rule is going to produce more of that problem than ours, because their rule is not that they have to strip search everyone for contraband, but their rule is they can make a choice. This Court in the Fourth, right, they say
well, I'm not sure if it's their rule or our rule. Ultimately, it's going to be our rule.
Yes. Okay. Well, then, first let me say I hope not. I hope that your rule is that there has to be a reasonable suspicion standard, which is the rule that was applied almost everywhere in the wake of Bell versus Wolfish without.
To do what? You
yes.
just said it's stripped naked. It's different from a strip search.
Yes, exactly.
So what is permitted? I mean, there are various things. One is showering in the presence of officers.
Showering in the presence of officers is not something that requires reasonable suspicion. The courts have uniformly concluded that if you are just generally in an area in which you're being monitored by the officers, that's not a Fourth Amendment search that violates a reasonable expectation of privacy.
They can be inspected without their clothes, just nothing more than that.
There are two different scenarios. One is a common room where everyone is standing around, and for jail security purposes, a common room, a common shower area. And, of course, for security purposes. This is different, Justice Ginsburg. You asked what's prohibited in the absence of reasonable suspicion. What's prohibited is standing 2 feet away from the person.
No, I want to know what's permitted.
Yes. What is permitted is anything — what is not subject to a reasonable suspicion standard is anything other than looking at a close inspection of the person at arm's length. What the courts of appeals have uniformly recognized in the lower federal courts, what the literature recognizes, and really what I think concerned this court in the Safford case, is that when you're standing so close to the person, inspecting their genitals, looking directly at their most private parts of their bodies, that is a direct intrusion on their individual privacy.
Sorry, are you suggesting three different levels? Stripping naked. It's okay to stand 5 feet away but not 2?
I don't think that the courts have had to confront 5 feet versus 2 feet. What they have confronted is they acknowledge that jails are places that require security. And so if you're just observing a shower room, that does not implicate a reasonable expectation of privacy.
So are you taking the position that it's the purpose of the search?
No, I'm taking
that's at issue.
No, it's the closeness of it. There is not a problem, I think, with the question of 2, 3, 4, or 5 feet. These searches all occur in the same way, and that is the officer stands directly in front of you. The testimony here is 2 feet away. This seems to be the common 3.
I'm still unsure. If it's okay to shower and have an officer watch you shower naked, what is the greater intrusion is that you're standing 2 as opposed to 5 feet away?
2 versus 10 feet away or just generally observing the room. This is exactly
that's a line that doesn't make much sense to me.
Oh, okay.
Let's go to the next line, which is that's one kind of search. The second is, I think, what some have called a visual cavity search.
Yes.
Whether you're going to have the individual open or expose private parts.
Yes.
Can you make an argument that that's different than just a visual search?
You can. So let me just try and close off my answer to the question of the 5 versus 10 feet and then turn immediately to this visual body cavity search. Remember, the court will recall that this is a reprise of the argument in the Safford case where the schools there argued that, well, there's an observation of these students in gym class. They shower together naked. They undress naked. And the court said it's quite different when you're standing right there looking over the student. Now, and so that's what implicates the Fourth Amendment right of privacy, and the distinction did make sense. As to your question, yes, there is a material difference, we think, although we think both should be covered by our rule. But a visual body cavity inspection, as occurred in the Essex facility here, where you require someone to bend over and cough, which is what the testimony is in this case, is
one, not the other.
That's correct. The second jail had a slightly different search protocol in which the testimony is that he was required to bend over and cough and expose his anus for inspection. And the respondents themselves regard that as a more significant intrusion, and they apply a reasonable suspicion standard themselves to that.
What you propose is reasonable enough, I suppose, and some states could adopt that kind of a protocol instead of what they have. But what you're asserting is that the Fourth Amendment prohibits them from adopting it. And the obstacle I see is that at the time the Fourth Amendment was adopted, this was standard practice to strip search people who were admitted to prisons. So how could it be deemed an unreasonable invasion of privacy when it was done all the time and nobody thought it was unconstitutional?
We don't believe that the premise is correct. If you read the history differently than me, I'm not going to be able to persuade you. But our understanding of the history is that the closest they can come to is two things. First, that people were strip searched upon arrest, and that's certainly not the rule under the Fourth Amendment. And that in certain jails at the time of the founding, other inmates in a process of abolition would, as a almost kind of ritual cleansing, would strip search new inmates. It had nothing to do with the jail officials themselves or trying to intercept contraband.
That is somehow less of an intrusion on your privacy to be naked in front of a whole bunch of inmates rather than one jail official inspecting?
Well, first, it wasn't the nearly uniform practice that I think your question assumes, and it's just a different kettle of fish entirely. That we don't believe, obviously, that historical lesson obtains today, that the prisoners can strip search new inmates new arrestees as they come in. I do agree with the basic premise of your question that our position can't just be that, hey, I've got a reasonable rule. I do have to, in either under the terms of Bell versus Wolfish or Turner versus Safley, establish that this is an exaggerated response, that this is much more, materially more than is necessary to accomplish their goals.
But less intrusive than the search in Bell against Wolfish, which involved pretrial detainees.
No, Justice Ginsburg, we disagree with that. At least as to the second search, we think that there's no difference between the degree of intrusion here and in Bell. But there is another significant reason that this, not just in the nature of the search, but a big difference between this case and Bell is that the inmates in that case made a voluntary choice. They decided to have the contact visits that
Do we know if the pretrial detainees in Bell were also inspected on entry into the facility?
We do not. I tried everything I could to check the record of that case, and there was no record of an admission strip search at the MCC at the time.
Counsel, there's a distinction between the simple strip search and the visual body cavity search. You say that they apply reasonable suspicion standard to the visual body cavity search.
Yes.
So is the visual body cavity search therefore off the table?
No, it is not. We contend that the Fourth Amendment prohibited the visual body cavity search at the Essex facility. So
Right. But you would say that they had to have a reasonable, articulable suspicion before they could do that.
We say that under their written policy they should have, but they didn't. The Burlington County, the only evidence about a conclusion of the jail about reasonable suspicion is that the Burlington County intake officer filled out a form saying there is no reasonable suspicion here. And Essex, I don't believe, contends that there was reasonable suspicion to engage in a visual body cavity search. They deny, as a matter of fact, that it happened.
So you see a distinction between what they actually do and the written policy?
I do with respect to the Essex well, I apologize. No. What happened here is that Essex, after this search occurred, and this is described in the Essex brief in opposition, in case you want to look at it later, at 3 and note 1, Essex, after the search in this case, changed its policy. Right. We were denied a injunction going forward under L.A. versus Lyon. So it's just a question of damages for the search that occurred at the time under their old policy.
I'm confused about your position. Suppose a jurisdiction has the policy of requiring every inmate who is arrested and is going to be held in custody to disrobe and take a shower and apply medication for the prevention of the spread of lice, and is observed while this is taking place from some distance by a corrections officer, let's say 10 feet away. Does that require reasonable suspicion?
It does not.
And so your only concern is searches that go further than that.
That's exactly right. The very close inspection of the individual's genitals, which can occur absolutely, so long as there is some minimal level of suspicion that's created. I do want to return to Justice Kennedy's concern about dignitary interests here and whether drawing any...
Could I just follow up on that? Is there a dispute of fact as to whether anything beyond that occurred in Burlington County?
In Burlington County, there is a dispute about the so-called genital lift, whether Mr. Florence was required to lift his genitals or not. There is no dispute that he was required directly in front of an officer to strip naked, despite the officer having made a finding, which is in page 390 of the Joint Appendix, that there was no reasonable suspicion to conduct a strip search. That is the only factual dispute in the entire case.
Could you clarify 2 points for me? The first is, was he admitted into the general population at Burlington?
The record is not entirely clear. What the record says is that for the first few days of his stay, remember he inexplicably was kept for 6 days. For the first several days, he was kept in a cell with only one other inmate or possibly two, and one time he had lunch with other people. In Essex, he was admitted to the general population.
The prior charge against your client was involved the use of a deadly weapon. Assuming the prison knew this,